Okay, so let's look at some of the legal issues for how the law has tried to deal with some of these things. And to set this up, I've asked you to read a couple of Supreme Court cases on the question of speech and obscenity. If you think back to our first module in this sequence on internet governance, of course, one of the issues we looked at was speech and anonymity, and the notion that something that there is some sort of right to anonymity, and that something that the internet does is facilitate people being able to speak anonymously. Now, that can be a good thing and it can have all kinds of benefits, but as we have seen, it can also facilitate all sorts of criminal activity. And the question is, how, if at all, can the law draw lines to try and protect minors and try and protect society in general from things that we might think objectionable? And this line of cases, early line of cases involving obscenity in the pre-internet days, leads into our discussion of child pornography today online. So the first case I asked you to look at is really the one of the seminal Supreme Court cases on pornography, which is Miller v. California. And Miller really sets out the current test for determining whether something is considered obscene. The background to all of this is that if something is considered obscene, government can regulate it facially. But first of all, you have to decide, is it obscene? So Miller is looking at some previous law about what would be obscene, and this is previous case law, the Memoirs case. And the Memoirs case has this test that I put up here on the screen, and it's really about kind of what is the theme of the material. Does it relate to a prurient interest in sex? Relates to contemporary standards, and talks about it being utterly without socially redeeming social value. And in the Miller case, the court says that test isn't really clear enough, isn't really specific enough, and tries to create a somewhat more specific test for deciding whether something is pornography. Whether something is obscene. And so this is the test articulated by Miller. And, of course, the second part of the test talks about whether it is depicting sexual conduct and has this language in a patently offensive way. But notice the two prongs around that, A and C. So the first is this community standards prong, whether the average person applying contemporary community standards would find that the work taken as a whole appeals to the prurient interest. So we have to ask what community and what standards. And then the final part of the test, whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. So the intent of the test is to look to community standards and then to ask, if it is something that's offensive, does it have some other kind of value that the First Amendment might protect? Relevant community that the Miller Court gives us back in 1973 is a local community. The Miller Court says it's not realistic or sound to suggest that we can kind of aggregate across different communities in the United States. Has this nice, colorful language. We can't expect a person from Maine or Mississippi to find tolerable the same things that are found tolerable in Las Vegas or New York. Now, there is a dissent in the Miller case from Justice Douglas, and Justice Douglas says that this whole idea of community standards is really not a good idea. Something might be shocking to me, but might not be shocking to my neighbor, and it shouldn't be the case that I could impose sort of my shock on my neighbor. Douglas has some good language too. What causes one person to boil up in rage may reflect only his neuroses. A good sort of 1970s pseudo-Freudian kind of language that we might not quite use as much anymore. Another dissent from Brennan, Stewart, and Marshall saying the particular statute at issue is overbroad. Nevertheless, the majority opinion stands, and that test has sort of stood the test of time, at least insofar as it's hasn't been overturned, and it's kind of a test that it's been criticized in various ways, but courts still use. Now we have to ask the question, all right, how does all this apply to the kind of obscene material that we might call child pornography? Do we have to look at child pornography and say, well, in some local community in Las Vegas or some local community in New York or wherever it might be, people are a little more accepting of this kind of thing. And the answer the Supreme Court said was no, and this is New York versus Ferber. So Ferber says, okay, if we're dealing with work that is involving children, does the state have more latitude than Miller might otherwise apply to prohibit that? And Justice White issues the majority opinion, writes the majority opinion, and White says, yes, the prurient interest standard is going to be relaxed when it comes to depictions of children. Effectively, the Supreme Court is saying this is really always appealing to the prurient interest. We don't have to kind of show what the average person in the community would think. This is as sort of a policy matter. We're saying if it's involving depiction of sexual acts and children, it's already going to satisfy that part of the test. We also don't have to look at whether it's a patently offensive manner. Again, we're kind of assuming it's patently offensive as sort of just a policy decision. We don't need to consider the material as a whole. We can say that, there might be a lot of other stuff in this material that is not offensive. Maybe there's stuff that's just adult pornography that in some communities wouldn't fail the Miller test, or maybe it's stuff that is just pushing the edge that doesn't involve children, or maybe it's stuff that's totally benign. Even if there's one scene kind of involving what we might call child pornography or depiction of child sexual acts, we can look at that and say that alone could allow regulation of this. And there's a bunch of policy reasons which probably are intuitive to you from the Ferber case. There is, of course, a compelling state interest in the protection of children. There's really no other way to stop the kind of trade that already existed then in child pornography. There is an intrinsic connection between the production of child pornography and the abuse of children. We presume that children don't have the emotional, intellectual capacity and so on to really consent to these kind of activities, and we don't want to presume that. And so there's always a question of abuse. And as you saw in that little video clip, and if you talk to any of the people that prosecute this, there's some really horrific abuse that does go on. There is an economic motive to produce it. People are making money off of this material, and we want to stop that. There's really not much value, if any, in any of this kind of material, and because the problem, the evil that is sought to be prevented by the law is so extraordinary, we don't have to really look at everything on a case-by-case basis, but we can, the court says we can really look at this on kind of a global policy basis and make a decision that this kind of material really doesn't have any protection at all. Now, there are some kind of limitations in the Ferber case, and one of those is talking about, well, what about other material that depicts sexual conduct that isn't otherwise obscene, doesn't involve a live performance or a reproduction of a live performance, doesn't involve this kind of thing with children. Does this retain First Amendment protection? And part of what's getting at here is something like a medical manual, right? So let's say a medical text on adolescence, which has pictures of prepubescent children. That kind of thing, the court is trying to say, wouldn't be considered obscene. It's a different kind of purpose. So see, even here, even with the Ferber case, it's difficult to draw can be difficult to draw these kinds of lines. And in the Ferber case, ultimately the court says the statute at issue was not overbroad. It was pretty well targeted toward the kind of child pornography materials that the court has said can be regulated. So take note of the concurrences in this case, because they highlight some fault lines that are going to show up in some of the next cases that we'll look at. So Justice Blackmun with O'Connor says, even if we were to say that some piece of material has some literary, scientific, or educational value, it still could be constitutionally banned because of this compelling overriding interest in protecting children. Justice Brennan, with Justice Marshall, on the other hand, says, well, wait a minute. If we read this, if this statute were applied to material that had serious artistic literary value, that could be a real problem. And as applied, the statute could be unconstitutional, though that wasn't the kind of material at issue in this case. So Brennan and Marshall were willing to go along with the majority in this case. And then there's Justice Stevens. And Justice Stevens, again, writes to say that this defendant had traded material that was clearly salacious, but there are other kinds of conduct that might not be covered. And you'll see Justice Stevens kind of show up several times again in some of these later cases. Justice Stevens very concerned about not impinging on First Amendment values. So there you've got kind of the basic outline of obscenity law, and then the kind of stronger protections for children and even less protection for material that could be called child pornography.